was a little boy who lived next door to us. In my mind, we will always be like 5, 6. So you just start everybody's day now that you. I see. Which one? What's your name? Sam. Like in my mind, he's still 6. Oh no, I'm very long. Everybody else. There you I have CI always found issues. You can't even in my friends, you know, I have this treatment. Anyway, we have the store go right through my front. I'm not just worried about
How are you? Oh, there's getting a bunch of new okay. How long have you been here? Oh, okay. Oh, God. It's getting itchy to get Alice. This is I think she's 7 here. Well, this is what I'm trying to do last year. Next year, I think it's next year, right? Of the kindergarten.
Oh, these are too.
Because they're growing so why don't you keep I mean, we feel like I feel like it's going up. Vaccine, they're like, but in America, you can't come to school. So you either go get one or you get a test.
You're associated never ordered anything anything that has like that you would put on a box
Hey everyone, we're just waiting for Matt Moody, which is the HOA Treehouse in the Woods attorney to come. So you can just bear with us for a moment. We're waiting for him. Thank you. We'll get started right after.
Am I in front of you? No, you're fine. You are totally fine.
It is so cold.
Oh, hi. Did your husband come? Okay, that's okay. No worries. I'm going to move this because we're taking a picture just of your back. Hey, Al? Oh, you think that's good? This is good. It's not going to fall over. And then have it start to cover it.
Red button. You're going to be here?
I'm not going to be here, but I don't know where Matt is.
I don't know. I think he just called.
He just called him?
Yeah, I've got maybe, and I've got a couple of things that it's funny, you just haven't gone on the list.
Thank you, everybody, for coming. This is such an amazing group. I have only witnessed like 4 or 5 folks every time.
69.
How many? 59?
69.
Oh, 69. We are still, I'm not going to wait for Matt Moody. He is the HOA attorney for Treehouse in the Woods. We're at 7:16, so we're just going to begin. Again, thank you for coming. Your voice is appreciated. Your participation is critical to the success of our community and moving forward. My name is Liz Lita, and I've lived here for 15 years. We have Bob, who is the current vice president, Bob Berman, who has lived here for 20 years. We have Al Perez, who is also a current board member. He is the secretary, and he has lived here for 17 years. We have Ted Gross, who is the outside counsel for the homeowners that I retained last week. Matt Moody is not present, but he will be at the end, and he represents Treehouse in the Woods. Ted and Matt, if he gets here, will speak to us in a bit, but first I'm going to give a synopsis of what has led us up to this point. At the June 21st Homeowner Association meeting, none of the homeowners were allowed to speak in the open forum. Each individual who raised a concern was dismissed by the president. At that meeting, Susan Feiner threatened to have me personally removed by the police for merely asking questions. There were approximately 25 of us here, which was a great success at that point. And so one of the homeowners suggested that we meet in private to discuss the concerns in our community. We met a week later at Panera, and we all had the same issues. And we all realized that we have been suffering in silence, and we didn't know what to do. One homeowner described, "I feel like a prisoner in my own home." And that response was because of the lack of cooperation by certain board members when verified gang activity, AK-47s, other guns were being run around our neighborhood with men in masks, drug dealing, and the SWAT team that was literally right down the street by the pizza place to come in and arrest these folks. The unwillingness of certain board members. Another homeowner said that I feel like I have to fight just to live here. A third homeowner indicated, I am 74 and I don't have the drive to fight with the president. I will probably just move, and I've been here for 20 years. We decided to get a better understanding of what the entire community felt, not just the folks that met at Panera. And so I sent out a survey so that we could get an accurate view of what everyone's needs and concerns were. The survey consisted of 20 questions, and they're available at the registration table after the meeting if you want to look at that. I thought that it was appropriate to put all 5 board members on the survey so that we could get a true, accurate depiction of what people felt. So I named all 5 board members. The results are as follows. 83% of the individuals that completed the survey voted yes, that they would be willing to sign a petition for the removal of Susan Feiner. 74% of the people that had completed the survey voted yes, that they would be willing to sign for the removal of Ruby County. 78% of the people that completed the survey voted yes for the removal of Jim Pye. 67%, excuse me, 67% of the individuals voted no, that they were not willing to sign for the removal of Al Perez, our secretary. 58% of the individuals that completed the survey voted no, that they were not willing to remove Bob Berman. After we had a good gauge of the community, Bob contacted Matt Moody, the HOA Treehouse in the Woods attorney, on July 12th, requesting the procedural guidelines for the recall of 3 board members, almost 30 days ago. Bob never received any communication back from Matt, and Al also sent email requesting that Matt advise him on the procedural guidelines that we would need to do in order for a recall. The board met actually yesterday, and Matt indicated that he was only allowed to speak to one individual based on his retainer agreement, and that individual was the president. Under our particular circumstances, it's very disappointing that we were not allowed to get that information 30 days ago. We learned yesterday at 7:41 p.m. that the likelihood of this special meeting would be contested in court based on a technicality. We could have done the vote tonight, as we met all of the requirements based on our bylaws. And we met all of the requirements based on the Illinois Condo Association Act and the 2023. However, now they want to turn to the Not-for-Profit Act, which requires a minimum of 20-day notice to homeowners. The alleged deficiencies that Matt is claiming are due in part by a lack of zero cooperation from Matt Moody and from Williamson Management. They created the problem. They would not give us email lists to all of the homeowners, yet now they want to use that as a defense for improper notification. I am not sure how spending our money to thwart our voices, to cling to a volunteer position, is a good return on our investment. And it is my opinion that the fiduciary duties are not being met by spending and throwing good money at bad. I have volunteered for the Basket Brigade for the last 6 years. We had a board meeting tonight, but I wasn't able to attend that because it's important that I'm here. It is also a 501c3, and we give complete Thanksgiving meals to individuals in need. Last year we gave 3,000 complete meals to families. If anyone ever on that committee came to me and said they wanted me to be removed, the last thing that I would do was to sue them in court and tie them up in litigation. The 2 attorneys, Ted, and if Matt gets here, came to agreement last night, even though we don't have to. We are going to allow them to renotice and push out this special meeting. It's just not going to be tonight. We are targeting September 8th, and I, like you, am disappointed with the fact that we need to push this out, and it would have been a lot more costly if we would have had to have gone to court. So we felt that this was the best course of action. I want to open up the floor to you guys. At this point, Ted will be able to speak to some attorney-specific questions, and we want to hear your voice. Your voice matters, and your voice counts. And we're going to get this place back on track. Thank you.
So let me first say that I am step over here. I have been retained by 2 of the association's members. I don't technically represent your group as a whole, right? I represent them. I don't represent anyone, the board as a whole. They have the association's attorney. So that being the case, though, it is my understanding that a number of your interests may be aligned with the 2 individuals some of you here that are not. That's okay too. I will also say that I just tried to, I did call Mr. Moody and I did send him that he will not be attending today. I don't want to necessarily think that's a negative thing because we did talk multiple times yesterday. So there, and at one point he told me he was coming, but then when we reached an agreement, it could have been interpreted by either one of us that our attendance here was not necessary. I did say I for sure would be here because I was asked to be. My understanding was he was asked to be here, but if things have changed, that could have happened. I was not aware of it, but he will not be coming. That is the email I received while Liz was speaking. The first thing I would say is I'm not going to divulge any of the attorney-client protected information that I have had with us, but I would say the summary that was just presented to you from a legal perspective. Let me step back for 1 second. I don't know all of the issues at your complex. I don't pretend to. I'm not here to make judgment on whether any of it is correct at the moment or not. I was specifically asked about this meeting. Were there processes followed? And if they weren't followed, were there reasons why any alleged failures to follow those processes might be excused? I think there is an argument that could be made. I think Mr. Moody and I both agree that we have some disagreement on some factual issues as to how that would impact certain areas of the law. But if we were to say that this meeting was going to steamroll ahead today, and I'll be damned, let's just do it and call it a day today. Take the vote because we have the numbers, or whatever the case may be. Whichever side you're on, either side, the winner or the loser, would be subject to potential court challenges because of certain interactions between various laws that apply to condominium associations. You're all aware of the Condominium Property Act, I assume, or at least exists out there. And in fact, that is the thing that makes you a condominium. My understanding is you might actually be townhouse-style structures. Is that?
Yeah.
And a very exact-looking buildings is yours. If it didn't say you're subject to the Condominium Property Act, then they would be a homeowners association. But because yours specifically says we're going to be subject to the Condominium Property Act, that's why you're a condominium. Your declaration is the law of the land, as it were, for your governing documents. Your bylaws, which is an exhibit to your declaration, is sort of the second in command, and then you probably, I assume that you have rules and regulations as a separate document. That is probably your third. You think of like the Declaration of the U.S. Constitution, your bylaws maybe as the Illinois Constitution, and the rules and regulations as Round Lake's ordinances, right? So that's the hierarchy. But despite those three, you're also an Illinois not-for-profit corporation. You're not a nonprofit. Liz's organization that she showed is a nonprofit. That means you receive charitable deductions and that sort of thing. You might also be a not-for-profit, I assume. But a not-for-profit means you're a corporation under an act that specifically says not-for-profit corporation. And there are benefits to being a corporation. It gives you corporate protection, particularly in your case, the condominium association, for your common area elements. If someone were to ever sue, like, I'm just going to make a hypothetical, someone slipped and fall on your common elements and they wanted to sue the association, as a corporation, it sort of protects you all as a whole, so that they don't come and sue every unit owner. There are all kinds of reasons why also the act, most declarations does requires that you be that. So you have those three documents, but you also have the not-for-profit corporation act, and there is a specific section in there that says, and by the way, I would agree with most of what Liz says. Again, I'm not going to divulge any attorney-client communications that we've had. She is one of the clients that retained me. I think that they did a number of things correctly. And I think that there are some things, even if they didn't, that could be overcome. If we were in court, I would be able to defend them. But, as any attorney will tell you, it's always better to reach a settlement than it is to just spend money and throw away. The only one who wins in that case is the attorneys, right? So while I think that any potential defects that might exist are defensible, and I have explained that position to the association's attorney, and to his credit, he also agrees that there's no point in just wasting money in litigation. I basically said, that being the case, let's try to reach something out, and by talking amongst ourselves, I think Liz summarized it here. Although I will say this, it's not necessarily true that we were picking September 8th. We were trying to put a deadline on the proposal was that we would have this meeting by September. At a time that was mutually agreeable to the association's board and my clients, which also then, obviously they can't pull everyone and come up with a date, so you'll get notice of it. The association will send out a notice that will be agreed upon by my review and the association's attorney's review about what's going to happen at that meeting. There are certain requirements that have to be in the notice. It is my opinion, Mr. Moody may disagree, but we didn't get to that part because there were some other things we discussed. It's my opinion that the current notice was sufficient, but whatever comes out, it will have for the next meeting, we'll have the approval of both of us.
With the outpour of people that came here, there's obviously there's sufficient notice for people to make it here, to make it be here representing themselves in our community.
Yeah, and I don't take it lightly that you all are here and probably frustrated by what you see as the delay. I don't. But I also think, as Liz pointed out, whether it was personal funds, association funds, or a combination of both, a lot of funds could have been, expended.
How do they get away with not giving us guidelines for recalling board members? I mean, that should be illegal to begin with.
I mean, there are guidelines, and you have to. They're in the law.
But where are those guidelines that for those of us that actually are the members of our community? Where do we get access to that? Because I haven't seen a piece of paper with any kind of guidelines that we've changed associations, like underwear. It seems like over the years.
Yeah.
I've been living here since 2002, and I have not gotten a revision since I bought my place.
So,
I'm just saying.
So
those are things
the
that are
provisions for
lacking.
removal are a combination of your governing documents, the Condominium Property Act, and the Illinois Not-for-Profit Act. And I will tell you that I used to, and have previously, and actually still do, represent a number of associations. And sometimes when I'm on the other side of this, the association has an obligation to do certain things. It's not necessarily, one of them is not to actually educate you all about your rights and obligations. And I know that sounds harsh, but
So should we
truthfully,
not get a copy or a board guideline?
if you don't have a copy of your governing documents, I would suggest that you contact your management company or your board. That is where those are supposed to, Section 18 of the Condo Act, one of the requirements is that your association will have a copy of its governing documents available for review and inspection.
I did create a website, it's called treehouseinthewoods.org, and the decks and bylaws and the rules are also on that. And that is a work in progress. I'm gonna put some folks on there for our unique systems, our HVAC systems, that some of us, it took years to figure out how to do it. So that's going up,
Tricks of the trade.
and I'm open to other suggestions, but there's comps on there for you guys to look at, and a whole host of things. It's treehouseinthewoods.org.
But I will tell you, I've been in it, 2023, right? So 1997 I was sworn in, so going on 26 years, something like that, as an attorney, and for a great majority of that time representing condominium and town associations as a good portion of my practice. Removal is one of the most contested, removal of board members is one of the most contested things that can occur, and one that is most ripe for legal challenges. So whether or not either side was correct in their positions yesterday, it just seemed like a more, all right, you have your position, we have our position, we both think we can win, but are we doing right by everybody if we just barrel through and roll the dice, as it were? And I will also tell you, quite frankly, I know that there are some of you who are determined to have a vote at some point prior to your annual meeting. The litigation would never be resolved prior to that annual meeting. So that being the case, I think both sides agree. I mean, you probably wouldn't even get a first court date before your next scheduled annual meeting, at which point, I'm just being honest, that's the reason. Or you guys are in Lake County, maybe you could, but
We can't wait that long, and we cannot wait that long.
but unlike, just to be pretty fair, but in Cook County, no way would you get a date before your next meeting. But that being the case, we will prepare. I will get together with Mr. Moody, he will get together with the board, and I will get together with my clients, and we will try to reach a number of dates that are mutual and agreeable, pick one. Notice will be drafted and prepared, approved by Mr. Moody, approved by myself. We'll go out, the management company will send it out, so we know that whatever is sent out will have been sent to all unit owners. It is my understanding that that the vast majority of people received or were otherwise aware of this meeting. That there could have been an argument that maybe some of them didn't get it. Why not people do or don't have the current list of homeowner is an issue I really don't want to go into, because that starts getting me into some of the attorney-client communications I had. That said, those are issues we probably don't have to address at this point, because we've reached this compromise as to how this meeting will take place going forward. There's also, and I'm glad to take questions. I'm going to stop here in a second. I'm glad to take questions in a second. There's also another impact that you have. You have something in your declaration, and we'll confirm whether or not it applies for this meeting, called cumulative voting, which means that you can vote in your normal. Let's just say, forget the removal thing for a second. Let's just say your normal meeting, if all 5 people were on, and you talked to me, so I'm picking on you. You wanted to vote. You can take your 5 votes that you had. You would have 5 votes for those 5 people, and you can put them all on him, which means you wouldn't vote at all for the other 4. Which means if everybody does that, that guy's getting elected, or even if a small portion of you do that, he's getting elected. So there's that issue that has to be worked out. In order to do that, you have to have certainty as to what units are here, and what percentage of voter ownership is here. You kind of need the management company for that. I mean, we have access to some of that, but if you really want to know for sure, you got to have the official record. It was unlikely that that was going to be here today. So that issue also led to the decision to move the meeting, or so that all the ducks, whichever side you're on, could be lined up in a row. I think that summarizes what I have to say, that I feel comfortable saying without divulging attorney-client communications. With that said, if there are questions, I will try to answer them as neutrally as possible. I know this gentleman was here first, so I'll come back around. He had to.
I was just
Not
wondering
you had your hand.
if you could just kind of walk us through what those next steps would look like. So we have the next meeting, 28 notices granted, follow the rules, and let's say the vote goes either direction. How does that, well, if it's in favor of them staying on, obviously nothing would change. But if they're voted to be removed, what does that look like from that day forward?
So that is one issue that Mr. Moody, well, so really that you're going to remove them, and one of the issues that Mr. Moody and I did not discuss is would there be an election for new members, or could the current board members, the remaining 2, appoint board members? I'm not sure the position he has on that right now, but I'm not sure I would divulge my position on that at the moment. I'm not trying to hide anything from anyone, but I haven't had an opportunity to discuss that with my actual clients at the moment. But those are the 2 real main options. But yes, if they're removed, those people are no longer members of the board.
One follow-up question. So who is Mr. Moody again?
His law firm, Kovitz, I think it's called Kovitz or Nesbitt now, is the association's retained attorney. I am here at the request of my clients, Liz and Al.
So he works for the association?
Yes.
Correct.
Not for a board member specific?
He is not board specific. He is not a board member specific. Right? He is retained by the association through his elected board.
But you said he can only deal with the president of the board.
I will, from what I heard from Liz say, I will tell you that most management contract agreements and most I don't use the attorney retention agreement for condominium and town associations, but I know there are other, that not just this firm, but other firms, not just Mr. Moody, but other firms do that. Often they will say you have to designate one person who's the point of contact. So let's just say, for example, that I was president and Al was vice president, but we disagreed on something, and then you're both calling the attorney. The association's getting charged to talk to both people. So usually they have you designate one person. My understanding, and again, without getting into whether the veracity of some of these things is accurate or not, that has stifled some conversations or communications. Maybe it has, maybe it hasn't. I'm not here to make judgment on that, but it is often usually a protection so that the association doesn't get a $10,000 bill because all 5 board members are calling their attorneys. So there is some utility to that kind of provision, but it can work backwards if that president is a lone wolf.
There should be clauses that allow that.
And And I say that not making judgment on your current president, I'm not here to do that.
No, it's just the way the legal system.
Can I go over there in order?
That actually just was my question, like the fiduciary duty of our association lawyer. At like what point does he have, to tell the president, like you have to do certain things in order to recall me, like you have to sit this out. Instead of, like threatening to sue.
I can't quite hear you, I'm sorry.
Oh, okay. So, I mean, it seems like a contradiction of the fiduciary duty of our attorney to say they're gonna take us to court when really he should be telling the president, they wanna recall you, you need to put this and this out.
So I just want to correct one thing, and I don't think Liz, it wasn't a misstatement. It wasn't that the association threatened to take Liz and Al to court, or that we threatened to take the association to court. We both asserted our positions. We both said that we believed them to be defensible in court. But if we went through today without these issues being resolved, it could go to court. It could go to court by people on either side, or if, let's just say hypothetically, there was a group of homeowners who are not currently have a dog in the fight, so to speak. They just didn't get notice of the meeting. And so they're totally independent. They say, hey, I didn't get notice of that meeting. That invalidates everything, whether you won or lost. And then you're all back in court. So that was sort of, nobody really, I suppose when you talk about it implicitly, there's a threat of court litigation, right? When you talk about this would be our argument, I think I can defend that in a court of law. And when Mr. Moody responds to me, this would be my argument, I think I don't want to give the impression, it wasn't a hostile conversation. It was matter of fact.
I think what you were getting at is more like, the individual in the board meeting person that we're having an issue with, the president and the attorney is only allowed to contact him. How do you, there should be guidelines that were set in place to be able to remove him without going and be able to still contact our association lawyer. And you think, that's just like, I'm gonna just take blanket impeachment. Oh, well, if we're gonna get impeached, we're not gonna do this. We're just gonna avoid it because he's not gonna bring it to the table.
So
it sounds like the law was not written in
I'll put it this way,
in order to make that exception.
I think Mr. Moody would agree with me that homeowners as a collective have an uphill battle against the association.
We're always.
And that is the nature of the beast. I have represented plenty of associations where I will be honest, I will tell you that I knew that. And I knew that if they didn't follow it.
You're working behind a property and you don't have control of anything safe, you're putting your life savings.
Listen,
I'm not saying that. It's just general law.
I want to tell you something. My first job while I was in law school, I was a law clerk, and then for 2.5 years, he now is a partner with Mr. Moody's firm, but he has his own firm. I worked for him. I said, in my 2.5 years of experience, I will never buy in a condominium or condo association based on what I've seen. But reality is reality, right? My ex-wife and I, when we were married, the first thing we could afford was a condominium association. Right. So despite now that I knew some of the things. So I would go to the board meetings and I was a pain in their butt, I'll be honest. Quite frankly. No,
I regret not being more involved.
But I knew what to say and how to ask, right? But if I didn't, we would have the same situation. So I don't know if that answered your question, but the reality is he has to follow what his contractual obligation is until he knows otherwise. And how does he know otherwise? Well, actions like this, right? So, and I think I will tell you again. He's not here. I'm not trying to defend him. I'm not trying to prosecute him either. We didn't have hostile conversations. It was matter of fact. These are our facts. These are his facts. Where do we agree on? What don't we agree? And how do we resolve the disagreement? And that's what we came up with. Is there one more here? I thought I saw another one there. Okay, I'm gonna go here then.
What happens if the association doesn't send out the notices again, or if they give out erroneous information on the telephone because they don't answer phone calls, but they do email?
So I will tell you this, while it was not a hostile call, I made it very adamant that on behalf of my clients that I did not expect any sort of shenanigans, and that if there were, we would address them appropriately and correctly, and quite frankly, that means through litigation work. I don't think anybody really wants that because it doesn't help anybody. But yes, that was contemplated, and that's why the agreement was it had to be done by September 8th, and not because otherwise it wouldn't put it off. I mean, I'm not saying they would, but they could, just put it off, right?
So will the association attorney then give what's been approved by the two attorneys? Will the association attorney then give that to the association president?
I think my understanding of our agreement, of compromise here is that once we've agreed on the notice, that will go out, that the notice will be tendered and on the date. Because that is an issue that hasn't been resolved just quite yet. But that notice, along with any other materials that are appropriate for that type of meeting, will go to the management company for delivery to the members at large. That is the process that has to be discussed.
So you'll actually get an email from a legitimate place, not from some erroneous THITW@Gmail, which nobody knows what the hell that was.
Well,
That's what I had to do.
I don't know if it'll be email or actual mail at this point, but I suspect it'll be.
It will be from Williamson Management.
The way it was explained to us was that once everything is clarified, balanced, and ready to go, then Williamson will be notified to send out a mailing to all of you. So that was what we heard yesterday, so we would
That
expect
is
that
in
this
line with
way
what
it's
I
made.
thought would occur, but I hadn't quite heard back on that issue.
Now, that's what Matt related to us.
I did have one over here.
I just have a question
Oh,
on
yeah.
that. Who's gonna notify Williamson?
Matt,
That is?
once they come to the agreement, I'm sorry if I said that, I didn't mean to jump in there, but
I saw you mouth there, but I assure you that my clients will be represented, and to the extent that happens to benefit others of you, so be it. So if it doesn't get out, it won't just be a black hole. So.
My question isn't necessarily to you, I don't know who could answer it, but are any of these three people that we want to get out up for election in January?
Yes.
How many? All three? Oh,
So worst case
Two.
scenario.
two.
So I will say this, I asked that question myself, or I don't know if I asked her or if it came up in our discussion, I don't want to misstate anything. But one of the things Mr. Moody and I discussed was trying to verify who in fact was up. It is theoretically possible, depending because of COVID and how things have happened in meetings or not meetings, and we're not the only association that might have experienced that, if that's what happened. It's possible that all five could be up, if you didn't reach a quorum in prior years, and they just stayed on because no annual meeting was technically held. So I don't think, at least as of yesterday, we didn't have an answer to that question, or a certain answer. Maybe it has since been resolved, but if it is, he and I was unfortunately out of the office most of the day today, so he and I did not have an opportunity to address that for this one. So I guess the answer to the question is who's up? It could be anywhere from 2 to 5.
Well, there is three board members are there up for election, but only two of the ones that they have been for election.
which names?
It's Susan Payne and Ashley Calvin.
Susan and.
Ruby Calvin.
Ruby.
So it sounds that's one.
So if you realistic,
Realistic what? Oh, you will have an answer by September 8th. You will have a meeting and a vote by September 8th, or there will be other action that's taken. Yes, sir.
Now, the notification date, would it reset with the new notification, or would it be backdated to the time of the initial notification for the 20 days?
So the reason September 8th was picked is because you're resetting the notice. So like if the notice went out today, which it didn't obviously, right? Because the mail has already come and gone. But if notice were to go out, let's say tomorrow, the earliest you could do it would be August 30th. Well, that seemed like it wasn't going to go out tomorrow. So that's why the following week was picked to have a cushion to allow for 20 days to go out. It was agreed that we would use the existing petitions that were generated by the homeowner. I'm sorry? We didn't technically vote, we just made a petition to call for the meeting. So no, right.
Which we're not talking about right now.
Okay.
Yes,
So
we do.
the answer is yes, notice will reset, but it'll reset as of the day. My guess is sometimes within the next week will go out.
I have a question on that. Are we still having a regular board meeting this month?
Yes.
Yes.
The regular meeting will go on as always.
Because there's other issues like,
Yeah, so, yeah, everybody is encouraged to attend the next board meeting on the 16th.
August 16th.
August 16th.
Oh, yeah.
Yeah,
Please,
yeah.
more than merrier. Seriously. Love to have you all.
Any other questions? Thank you guys so much. What's our count, 69?
Well, 69, but I saw more people came in, so.
Okay, so 70s. In the years past, there's been 4 or 5.
32%.
It's, what's the percent?
32%.
32%.
Out of
In attendance.
220.
And actually, we have some investors that are here that represent 6 votes, so there's a lot more than just what you're seeing as individuals here. So we'll let you know, Williamson will send out a mail to you, and then we'll post. Yes, ma'am?
When you say 210, that's how many
220.
votes out of the vote or out of the unit?
We have 220 units in the subdivision.
Okay.
So Cheryl just said 32?
32% showed up.
32% showed up here.
Showed up.
Well, that's actually not entirely correct, because there's husbands and wives, and so it's not per resident. So it needs to be per resident, per household.
Yeah, but only the one person signed.
And one person, right.
You'll have better numbers.
So we'll get those signs changed to the new date, we'll put those postings out and look for stuff in your mail. Oh, yes, Steve.
Is there any, minimum amount of homeowners that have to vote in order for the vote to, once it's been sent out as a notification to a certain amount of people have to vote before it can be certified as a legitimate ratified?
The petitions
ratified?
was 20%, we met that requirement
Oh, okay.
and exceeded that.
What about to remove them?
We have a number of those already in proxy form.
Right,
We'll still
so
take those.
what I would say is that is one of the, that might become one of the issues. So I'm gonna just ask my client,
Yeah.
not talk about
That's why I
that.
said to
Yeah,
Sue,
so-
not to discuss
Okay,
that.
So, you know, we're trying to, I think we'll reach a resolution on that, but until so, I would rather we just not.
Okay.
You want to have all the bylaws or?
Is what information available?
Just that,
Yes,
Does that be-
all that is in the bylaws, but as he said, there's
So
a.
I would say to you that can be found in the combination of your bylaws, your governing, your other documents, the condo act, and the not-for-profit act. And I'm not sure that there's a dispute about what that number is, but it wasn't fully addressed because we were addressing the more pressing issues. So just in case, I don't wanna be on record saying I agree that this number or this percentage is necessary, just in case, as we get closer and we review these, some of these differences.
And if you guys have any questions, feel free to email the Treehouse in the Woods, or I'm sorry, it's THITW@gmail.com. And that comes to my office.
So we finished.
Yeah.
Hey, can you repeat the email?
Well, we thank everybody.
THITW, the acronym is Treehouse in the Woods, roundlake@gmail.com.
Round Lake is spelled out, right?
It is.
We thank everybody that came tonight, and we hope to see the same people and more on the next meeting for the vote. And you have the website. If you have any questions, just click on the email link on the website and ask any questions you might have. We will be happy to answer. All right?
If I may say one thing when else.
Just go for it.
We've never had a turnout like this. And I've lived here 23 years, been on board a major part of that time. And it is absolutely amazing to see everybody sitting in this room, okay? Normally, we're looking at 2 or 3 or 4 people. And no matter what side of this thing that you're on, I'm so proud of everybody for getting involved in this, okay? Because this is your community. This is your home. And we want to do everything to make it the best and most pleasant place we can for you to be able to live here, okay? So, thank you for being here. Thank you for doing what you're doing, okay? And we're gonna do everything we can do to make this thing way, way better, okay?
And let's wrap it up with giving everybody a big round of applause.
Hello, ladies. How are you? No, I'm in Gurney. But no, I'm right down Milwaukee. Right, exactly. Pages late. He has now right off. Pages late.
Yeah, that's the area.
It's kind of nice. It is. I really like it. How are you doing? Are you cleaning out?
Do it this way.
Good. Okay. Take care of you. Okay.
I'm okay.
It's mine.
I invited her because I thought you had a vested interest.
We all have
So when you do
Well, we can talk about this, because I have, some resources that I've worked with the senior
Then when I came back, it was
and I'm like,
this is your final year.
yeah.
Now, do you have sisters or brothers? I have from my father. I don't know if you know, because the conflict defense, our reality gets crazy.
They've moved over slightly. Yes. They probably got sick of me and David.
I said, I'll call the police, and I said, go right ahead. I've done it twice. But it's like,
I have too, just keep up with that, because then it'll make it go.
and they congregate one person.
You called, and nothing. It looks terrible. No, they're not supposed to. Well, it's 6 feet from our building as well. But, I mean, because so the building probably talking about, it's probably 6 foot. Okay. Problem solved. Your daughter sees them, right?
I mean, I probably got the information somewhere everywhere in our house, but I can't find it.
Over like 4 or 5 times, it's 5 property years ago.
Yeah, I know, she was here.